I'm very excited to be with you this morning. I guess it's morning for everybody because everybody's in the US. It is good to be here. I'm happy to be talking about this topic. As Andrea said, I am an estate planning and elder law attorney. You are welcome to ask questions in the Q&A as we go along. And I will try to answer them as we go along. My only request is that your question be something that other people care about. So any question that starts, my cousin, is not going to be a question that other people care about, but a question that's, hey, what does it take to have capacity to sign a power of attorney? Everybody cares about. So that's my only request on questions going into the Q&A. If you have questions about my cousin or any other specific information for you, you can email me later and I will put, well, all of my information is right here. My email address is kelly@georgia-elderlaw.com. And you can call our office. I can only help folks who are in Georgia, but I can help you connect to attorneys who are local to you as well. So, Andrea, we're ready to hit that first slide.
Yeah. Oops. Why isn't it going? There we go.
Awesome. So one of the big things that I do as an elder law attorney is I help folks access public benefits like SSI and Medicaid. I do not help people apply for SSI, but once they have SSI, I can help them stay eligible, financially eligible, or help them access other benefits that they're now eligible for because they have an SSI adjudication. So the basic eligibility is the same for both SSI and Medicaid. You have to have less than $2,000. So that is not a whole lot of money. And so there's legal planning that can happen to help folks with less than $2,000. With more than $2,000, get less than $2,000. So one of those planning options is a special needs trust, and the other fairly recent planning option is an ABLE account. And we're going to talk about both of those a little bit today, and then at the conference this summer, we're going to talk about both those in a lot more detail. The first piece is that you have to be, other than assets, is you have to be disabled. And the federal government has some real clear definitions of what it means to be disabled, but basically it means that there's something going on with you that prevents you from being able to work and earn more than $1,550 a month in income. And so that's called substantial gainful employment or substantial gainful activity from employment. And Social Security, like every federal agency, has lots of weird definitions for terms, but basically there's something going on that prevents you from being able to work and earn more than that. And that whatever is going on is expected to last more than a year or expected to result in your death. The rules are a little bit easier for children, folks under 18. There are more things that qualify for disability for folks under 18 than it is when folks turn 18. And so for folks with nutritional support, most children who are under 18 would qualify simply because they need nutritional support. For folks over 18, it requires a bit more than that. But if you happen to have a central line, that's often a thing in your favor if you're trying to get disability. So our two big planning options, I mentioned ABLE accounts, and I forgot to update this. The numbers changed last week. This year, you can contribute up to $19,000 into an ABLE account. So ABLE accounts are accounts that were created in the 401 code of the IRS. So that is the same type of code where we have 401ks, where we have retirement accounts. It's also very similar to 529 college savings accounts, but it's an account that can be created for a person who was disabled before age 26. So anybody can create it if the person they're creating it for was disabled before age 26. You can create it for yourself if you were disabled before age 26. It's self-reporting on if you're disabled. So you don't actually have to have a disability adjudication, but you have to have a history of some sort of impairment that's impairing at least one major activity of your life. Because the ABLE corporation that you're using may be audited, they may ask you for proof of that in the future, but it's not required to open the account. You can put money into your own ABLE account, or other people can put money into your ABLE account. And it's exempt from eligibility for benefits like SSI and Medicaid. So extra savings can sit in an ABLE account, and it doesn't count against you for SSI or Medicaid up to $100,000. You can only contribute $19,000 this year, $18,000 last year, $17,000 the year before. So it would take a long time to get up to $100,000. The really cool thing about ABLE accounts is when we distribute money out of the ABLE account, there is virtually no restriction on what we have to spend the money on. The legal term is a qualified disability expense, but they really haven't found anything yet that's not a qualified disability expense. So ABLE accounts can be used to pay for housing. They can be used to pay for food. They can be used to pay for entertainment. Anything you can think of likely can be tied to that disability. So ABLE accounts are super flexible, and the person who the money is for can use the account. And so that's a really cool perk of ABLE accounts, is that a person who has a disability under Social Security regulations can still be in charge of their own money. The other option that we've had for a long time are called special needs trust. Special needs trusts have some restrictions on how the money is spent. They have an annual accounting that the trustee has to submit to whatever agency they're receiving benefits from. And money in a special needs trust doesn't count for SSI or Medicaid eligibility, but the beneficiary, the person who has a disability, cannot be the trustee, meaning they can't be in charge, they can't have direct access to those funds. And if your special needs trust is something that you created with your own funds, it's subject to payback to Medicaid upon your death if you received any Medicaid benefits. So special needs trusts are a great option, especially if we've got more than $19,000, or if we have money that someone else wants to leave, or leave as an inheritance for someone with a disability on SSI or Medicaid. But there's some restrictions. Specifically, special needs trust just started in November, October, being able to be used to pay for food. And they still can't be used to pay for housing without a reduction in SSI benefits. And so special needs trusts are a great tool to help people have excess assets. They don't have direct control, and they don't get to be in charge of exactly how the funds are spent. So we're going to go to the next slide, Andrea. All right, so that was kind of the basics of what we're talking about when we're talking about benefits and why we need to do really most of this planning. And then we've got sort of 3 phases here for folks to think about. Some of this is planning for the person who needs nutritional support, and some of this is planning for those around them. This first one is really for parents to think about estate planning and how that's going to affect your child who needs nutritional support. So here's my children. And you can see our little guy on the left with the backpack is our child who needs nutrition support. So in my will, because all of these children are little, I leave trust for my kids. This says if my wife and I both die, everything we have is going to be in trust, and their godmother is going to manage it for them. So that's common for anybody who has young children. They're holding money. As you can see, they're just excited to have money. They have no idea what money means. They have no idea what the value is of this. They just know that I gave them money and that's cute. So they can't manage it. And legally, they can't manage their inheritance until they turn 18. So that's why I have a trust. Their godmother's managing things for them until they're 18. But my little guy with nutrition support, we don't know if he will meet the definition of disability when he turns 18. He's 5 now. He might meet that definition, he might not. And so we have got In our will a second trust called a special needs trust that says if anyone who inherits, so if any of my children are disabled when I die, their share is going to be held instead of in that trust that their godmother's managing just because they're a kid, in the special needs trust so that it doesn't affect their ability to get public benefits when they turn 18. And so that's a pretty big deal. So I've talked about the trust in my will. Wills also have an executor. The executor is the person in charge of gathering your assets and distributing them out. In this case, our executor is going to distribute out to the trustee, who's going to manage the minor trust because they're children, or the special needs trust that's in there in case anybody needs it. Also, they're itty bitty. They need a guardian. So my will says when I die, their godmother becomes their guardian if my wife is also deceased. And so those are the three big roles for people to do things in your will. Lots of people come to me and they haven't done wills when their kids were little because they could never figure out who the guardian was going to be. That's okay. Um, but we got to figure that out at some point. And especially if you're a parent of a child who needs nutrition support, it's a good idea to figure out who in your life might be able to take on that responsibility. Because we all know that means there's going to be more doctor's appointments than usual. They're going to need some ability to speak medical. And so it's a little harder for us to pick a guardian, but it's super important for us to pick a guardian. If we don't do a will and we die and we haven't named a guardian, then our family, siblings, parents, and those of our child's other parent are basically going to fight it out and decide amongst themselves. And that might not be the most appropriate person for your children. So it's a good idea to get a will and get somebody listed as the guardian and somebody listed as the trustee for your kids. Those do not have to be the same person. Mine are the same person because I've had lots of talks with the kid's godmother about all that that entails and the funding for all that that entails. But it doesn't have to be. There are plenty of families where we have one person who would be really good at the medical side and the caregiving side and maybe don't understand the money so much. That's okay. Name somebody else as the trustee who's going to manage the money for your kids. Our next section is going to be about young adults. And so I wrote young adults, but this really applies to all adults. Anyone who is over 18 needs to have a financial power of attorney and an advance directive for healthcare. You can't create it before you're 18, so that's why I wrote young adults. This is a transition time, but this is true for all of us. I'm going to assume if you're watching this that you are an adult on and that you're over 18. And so we will assume that you are old enough to complete a financial power of attorney. Financial power of attorney says that you are in charge of yourself and you are giving someone else the authority to make legal and financial decisions on your behalf. Then the advance directive for healthcare says you are over 18, you are in charge of yourself, and you are giving someone else the authority to communicate with your doctors. In most states, an advance directive for healthcare or a healthcare power of attorney, if it's broken out into little pieces in your state, excuse me, includes HIPAA authorizations. So this next sentence is for parents. Once your child turns 18, they are legally an adult and you no longer have access to their medical records unless they complete a HIPAA release or a healthcare directive of some variety that gives you the authority to access their medical records. If you do not complete these documents and something happens and you're no longer able to manage your affairs, on the financial side, we have no default. Nobody else can manage your finances. So if you have a child who's turning 18 and is not competent to be able to say, yes, I want my parent to manage my affairs anymore, Or if something happens to you as an adult and you're no longer able to say, yes, I want my sibling or my spouse or my best friend to manage my affairs for me, then your loved ones are going to have to go to the probate court in your jurisdiction, wherever you live, and apply for guardianship or conservatorship of you. So these are some terms that are Georgia specific, but I can tell you what the more general terms are. Guardianship is the general term. This is when you need somebody else to manage your health care for you. That you can't understand the health care, you can't express your wishes, whatever that is, that you need somebody else managing your health care. And so your loved ones go to the probate court and petition to become your guardian. Conservatorship is the financial side of that, and sometimes it's called guardian of the property or guardian of the estate. So conservatorship happens when you can't communicate your wishes about your finances, or you can't communicate how who you want to help you with your finances, or you can't understand or remember that you have already paid your bills or not paid your bills this month. Same thing, we're in the probate court, and the judge determines who's going to manage your finances. And that's either called the guardian of your estate or your conservator. It's only appropriate when we have folks who can't make or communicate their own decisions. And that's true countrywide. We are all entitled to make bad decisions. So I tell folks, um, if you have a loved one who is not able to get out of the house and they're eating food that has spoiled, and they know that they're eating food that is spoiled, but that's the only food that's available. So that's a conscious choice they're making. That's a bad decision, but it's one that they're entitled to make. If you have a loved one who's not able to get out of the house and their food has begun to spoil and they're eating that spoiled food and they have no idea why they have an upset stomach, that's a person who doesn't understand the consequences of their actions. So that person likely would need guardianship because they were making decisions, but they weren't able to understand the consequences of those decisions. And so that is my shorthand to help explain people the difference between making bad decisions and not understanding your decisions or not being able to make better decisions. So we've got a couple questions from that first section about ABLE accounts. We got a question, are there restrictions on where money comes from that goes into an ABLE account? No. So any sort of money that you have or your loved ones have can go into an ABLE account. However, your ABLE account can only receive up to $19,000 this year unless you're working. So if you, the person who qualifies to have the ABLE account because you have some type of disability, are working, you can contribute more than the 19,000. You can contribute usually like another 13,000-ish into your ABLE account of your own income. And then the question goes on, can you take the balance of a Roth IRA and put it into an ABLE account? Yes, but the Roth IRA is no longer an IRA. So because it's a Roth, we don't have any taxes due on that distribution out of the IRA. If you are a person who has been approved for SSI or Medicaid, there are no restrictions or penalties on when you take money out of a retirement account, like an IRA, a Roth, a 401k. That 59.5 restriction doesn't apply to people who are disabled. So if you have SSI or SSDI, the federal government says you're disabled and they don't penalize you for that early distribution. If you don't have either of those benefits, SSI or SSDI, the government does not say you're disabled. And so you would, when you took the money out of the Roth, have um, have a penalty for taking that distribution. If you are on Medicaid, when you do this, that distribution out of the Roth is income and could affect your Medicaid eligibility. But if you're taking that distribution out of the Roth to be eligible for Medicaid, because your state counts the Roth as an asset, then you've not got a problem because it's not going to affect your Medicaid eligibility because you're not on Medicaid yet. Can money from a 529 be deposited into an ABLE account or a special needs trust without penalty? Unfortunately, no. When we have money in a 529, if it's spent on anything other than qualified education expenses, that's going to create a penalty for a tax penalty that you'll have to pay a little bit of those funds back to the government because you use them, education funds, for something other than education. The other, I've talked a little bit about that transition at young adulthood, but let's talk a little bit more about advanced directives for healthcare. So advanced directive for healthcare, we're going to stay on that last slide, Andrea. Advanced directive for healthcare is our term in Georgia, and it's the term in a lot of states, but it really includes 5 different documents. So one is it's a healthcare power of attorney. It lets you name people to make healthcare decisions. It's a HIPAA release. It lets you give those people you name the ability to communicate with your medical team. It's also a living will. So a living will is a document that lets you tell your loved ones in most states, and in some states, your medical team, what your wishes are around end of life care. If you are terminal or in a persistent vegetative state, do you want any interventions that would prolong your life? One of those interventions in every state is, do you want nutrition support? And so that's really important for you to talk to your doctors about, is there a point where you would want to stop receiving supported nutrition? Is there a point where you would want to not receive anything by IV or not receive anything through your feeding tube? And that's a big question that I can't answer for you, but you need to have that conversation with your doctors, because most of the time when folks are filling out advanced directives for healthcare, they're being asked the question, would you want to start receiving these supports if these things were happening to your health? But for folks who are already receiving nutrition support, the question is there a point where you would ever want to stop receiving that support? And that's a different question altogether. Not one that I'm qualified to help you answer, but one that you can absolutely talk with your medical team about. And then the last piece in the advanced directive is, it's really 2 pieces, but it's 2 planning ahead questions. It's, when you die, what do you want to happen to your body? So some states have that as a separate document. It's a designation of pre-need burial wishes. And if something happened and you were no longer competent to make your healthcare decisions, and for some reason, the people you've named in your document as your healthcare agents are no longer able to make your healthcare decisions, and we end up in the probate court getting guardianship of you, who do you want to be your guardian? Most of the time, people say, I would still want the people I've named if they're able to serve. That helps us in the case where family starts fighting. You have named one sibling and a different sibling disagrees with those decisions and is trying to take control, in which case your document is telling the court, stick with the people I picked. But it also could be, if something happened to the people you picked and they're not able to serve anymore, your family still might end up in court trying to figure out who's going to have authority to help next. So when that happens, we've got um, we've got one way to try to help with that, which is name backups. So name that first sibling you want, and if they're not able to serve, then go name another sibling. Name a backup. Name 2 backups. I've named as many as 5 backups before, so that we never get to the point where the people that you wanted to serve aren't able to, and we don't have any backups. We have more ABLE account questions. It seems wise to put money in an ABLE account because you can access it. Is it also available for a direct beneficiary? Yes. So if I were a person who's at least 18 years old and I had a disability, I could create my own ABLE account. ABLE accounts, even though it is a federal law, are administered at the state level. So you have to use the ABLE account as administered in your state. So if you just Google your state and ABLE, you'll be able to find the website. Basically, it works as an online bank. The state of Ohio actually manages, I think, 14 ABLE accounts for different states. They manage ours here in Georgia. They were one of the first states to get going with the ABLE account. But if you Google your state and ABLE, you can find very quickly, top hit should be whoever the manager is for your state's ABLE account. It is all managed online in every state. So it's an online bank account. Often you get a TrueLink card. If you're not familiar with any of this disability planning, TrueLink is a type of prepaid debit card that you can set restrictions on. So if you're managing an ABLE account for a loved one, you can log into your ABLE account and you can set restrictions on how they use that TrueLink card, that debit card that goes with their ABLE account. I love ABLE accounts. Um, so the person who asked, it seems wise to put money there. I absolutely agree. The only potential downfall of an ABLE account is when the beneficiary dies, under the terms of the rules in your specific state, the funds left in the ABLE account may go back to your specific state. So you just need to be aware of what happens to the funds that are left in the account when um, when the beneficiary passes. And that might be back to the state, it might be to other heirs, but you just need to read the terms for your specific state. So we don't want to overfund an ABLE account, but it is a great option for being able to hold on to some extra funds. We've got a reminder, if you have questions, put them in the Q&A. We're not using the hand raise feature, and we're not using the chat function today, just the Q&A. All right, Andrea, we're ready for that last page. So the last section is about retirement and future planning. And this is really more geared for parents who are providing care for anyone with a disability, including a child who may be on nutrition support. If you are a parent and you're providing care for someone else, we need to figure out how their care is going to be managed when you're not able to provide that care anymore. And it might be that it's just that your child is now too large for you to be lifting them. And so with some lifts coming into the house, we might be able to continue to have them at home with you. But at some point, you're not going to be home with them. And what does that look like? One of the best things you can do is write a letter of intent. This is not a legal document. This is, what are your goals for your loved one's future care? What are their goals for their future care? And then how are we going to get those managed? Who are we going to have being in charge of getting your loved one to the annual family reunion? Who are we going to be in charge of making sure they go to a baseball game each season? Who's going to be in charge of physical care? Are they going to continue to live independently? Is your loved one going to continue to, are they going to need to move out of the home? Are they going to be able to live in a group home or in an adult foster home? Are they going to need to be in some type of assisted living facility or in a skilled nursing facility? What's that going to look like? If you don't have other close people or you don't want to put some of this responsibility on a sibling, for example, there are professionals you can hire to be in charge of the management of this. There are professional trustees. The bad news is most of them kick in at about $1 million. So we got to have substantial savings or substantial life insurance to be able to fund to have a professional trustee. There are care managers. So care managers are one of my favorite things in this sphere that no one's ever heard of. Their technical term is aging life care managers, but they serve clients, patients from the itty bittiest 2 and 3 month olds all the way up through the end of life at 100+ years old. Care managers are typically nurses or social workers who have experience managing care for other people. So care managers are folks who can make sure that we've got the right level of care coming in. They're folks who can connect to other resources. They're folks who speak the same language as doctors do, and so are able to go to doctor's appointments and then interpret that into English. They're folks who do all those things that you do, manage the calendar of caregivers. All those things you do, we can hire that out if there's not a clear person to be able to do that in the family. Just like I said earlier, we need backups on your healthcare directive. We need backups on your financial power of attorney. We also need backups on your trust. So if you're leaving a special needs trust for a loved one, we need to make sure we've got 2 or 3 layers of backups. And we might even want to say that your loved one, if they're capable of it, can name their own successor trustees if the people that you've named are all not able to serve. That's a case by case thing, but we need to make sure we've got a plan for who's going to be in charge of managing finances and who's going to be in charge of managing care for your loved one's lifetime. So retirement planning is also, where are you going to receive care? If you are the parent of a person who needs additional care and you start to need care, because providing direct hands-on care is hard. It's hard on our body, it's hard on us emotionally. Caregivers often need care because of an injury or because they've just worked their body too hard. So, are you going to be able to live at home? Can you afford to bring in caregivers? Do you need to move out of the home into assisted living? And if so, is your loved one going with you? Are they going to have a room? Are they going to share a room with you? Are they going to have their own room in the same type of facility, in the same facility? So it's planning beyond just your loved one who needs care. It's also planning for you and how you're going to get the care you need. So for parents on here, purchase long-term care insurance for yourself. This is kind of the best investment you can make, is making sure that your care will be covered. Folks with disabilities typically do not qualify for long-term care insurance unless they're buying it through a group bundle, such as through an employer. So if you're an adult on nutrition support and your company offers long-term care insurance, figure out if that's a thing you can afford. Try your hardest, even if it's a little stretch, to figure out how to afford those premiums, because that's the only way somebody who's already receiving nutrition support is going to qualify for long-term care insurance, is through a group bundle, like through their employer. What other questions do we have? Because I can talk for 20 more minutes, or I can answer y'all's questions.
See, I would say keep going and then we'll just look for more questions if you have more talking to do.
Oh, I can talk all day. So, um, so we've talked about powers of attorney for us as adults. The bit, well, before I do that, this is a really good question. It feels overwhelming. If we haven't started, where do we start? The best way to start is to find a local attorney who's familiar with these topics. So, special needs attorneys are really difficult to find because a lot of attorneys don't actually market specifically as special needs attorneys. So there is a Society of Special Needs Planning. I looked it up recently among attorneys I knew and couldn't find most of them that I know do this type of work on there. You can find good financial advisors through the Society of Special Needs Planners. So the best place to find lawyers who know about this is the National Association of Elder Law Attorneys. So the website is NAELA, Naela, National Association of Elder Law Attorneys.org. So naela.org. And you can, right on the homepage, there's a Find an Attorney button, and you can put in your zip code and find somebody, usually within 100 miles, most of the time even closer than that, who's going to have experience with this type of planning. I pray for you. They're going to make your life not feel more stressful. That is our goal here. I think that's true of most folks who identify as elder law attorneys, but trying to give you little bits to get started on it is going to be the attorney's job. All right, and we got a second question about special needs trust. So, special needs trust is a trust. We've got two kinds. Let me start there. I didn't do a good job with this earlier. We have two kinds of special needs trust. First party means I have a disability and I am putting my own money into the special needs trust so that I can become eligible for benefits like SSI and Medicaid. They have a $2,000 limit. So the restrictions of that special needs trust that I'm creating, this is first party because it's me. I'm the first person. I'm creating it with my own money. I can't be the trustee, so I have to name someone else to manage that money for me. And when I die, whatever's left in my first party special needs trust goes back to Medicaid. So if I've received any Medicaid benefits, Medicaid gets paid first. And if there's anything left after Medicaid gets reimbursed for everything they spent on my care, then that goes to whoever else I've named in the trust. So that's a first party special needs trust. It makes me eligible, but I can't be in charge, and whatever's left goes back to Medicaid. A third party special needs trust means I am creating a special needs trust with my money for someone else who has a disability. So this is the kind of trust often that's created in a will or that's created so that grandparents can leave money into a special needs trust for a grandchild, or aunts and uncles or other people are typically leaving an inheritance in some type of special needs trust. So this means I've created in my will a trust that says if my son is receiving any type of government benefits when I die, if he's been determined disabled when I die, his share goes in this third party special needs trust that's inside my will that he's not the trustee of. The trustee can spend it on anything other than housing, and it doesn't count for his Medicaid. And when he dies, it goes to whoever else I've named as beneficiaries after him. So the con is he's not in charge, he doesn't have direct access, and he can't control that money. The pro is he's still getting Medicaid. His inheritance from me didn't stop that. And so you can create a third party trust either through your will or through your estate planning, or you can just create a separate trust. And then you tell everybody in the family, here's the name of the trust where you're going to leave Jameson's share. And so if you want Jameson to inherit anything, it goes into Jameson's Special Needs Trust. And here's all the details. So somebody is asking questions about the $2,000 asset limit for SSI and Medicaid. So for SSI and Medicaid, what doesn't count is your home, one vehicle, and $2,000 is your asset limit. In some states, you can also have retirement accounts for Medicaid. It doesn't help with SSI eligibility, but for Medicaid, if you have retirement accounts, they don't count in some states. They really don't care about your stuff that's not titled. So like your couch, your clothing, they're not super worried about the value of those. But you can only have one car. If you have a second car, it counts towards your $2,000 asset limit. So that second car needs to either be sold, or you're not going to be eligible unless it's worth less than $2,000 and your cash also combined with the value of the second car is less than $2,000. One option is to turn over the title of a second car to a special needs trust. It is very difficult to insure vehicles that are owned by trust. So that's not a great option unless it's a pretty valuable vehicle and you need to have that vehicle for some reason. The way this question is asked makes me think that they might also be talking about either a married couple or parents applying for a child. SSI, when we're talking about something other than a single adult, other people's assets are deemed. So some percentage of a parent's assets are deemed the child's assets when you have a child under 18 who's applying for SSI. If you're married, a percentage of your spouse's assets are deemed as your assets when you're applying for SSI. So unfortunately, this is a huge issue for adults in that the government is strongly encouraging disabled people not to get married because we don't want your spouse's assets to count as your assets. I don't love it. Unfortunately, marriage is a real detriment most of the time when we have folks who are receiving SSI or Medicaid and they're trying to get married. It can really cost benefit issues. Back over to the power of attorney. All powers of attorney are not created equal. So, if you have a financial power of attorney that you have signed giving other people power, and it is 1 page or 2 pages long, and it says my agent can write checks, sell my house, and do anything else I can do. All they can do is write checks and sell your house because anything else you can do is not specific. Powers of attorney in every state have to be specific. The people you've named as your agent can only do the specific things that the document says they can do. So even though it's called a general power of attorney, it needs to list out everything you want them to be able to do. It needs to say they can hire caregivers. It needs to say they can close bank accounts. It needs to say they can create a trust for you if we need to do that in the future. It needs to say all of those things. The good news is most states have adopted, this is silly legal terms, a Uniform Power of Attorney Act, which means most states are using the same form these days. And that form includes all these basic things I just mentioned. Hiring caregivers for your care, making sure you have a financial advisor or attorney or accountant, and that your agent can hire those people. Creating trust in the future if you need that. Doing planning to get you eligible for benefits like SSI and Medicaid. The statutory form in, I think the last count was 37 states, includes those powers. So that's great news. You can usually find that in your state for free. There are other things that might be necessary to do this, to do all of that planning, to create a special needs trust, more importantly, to fund a special needs trust with your own money, that it's helpful to talk to an attorney, specifically an elder law attorney, to see if you need additional powers. Does 529 money count as an asset? Yes. Medicaid and SSI both count money in a 529 as an asset. So, although it feels great to be funding a 529 for your children, if you have a child who's likely to need SSI when they turn 18, you may want to transfer that money into an account for one of your other children. 529 has some specific rules about what counts as far as who is a family member that you can transfer those funds to. And so if you go back to whoever you've invested your 529 with, you can find those rules about who you could transfer those funds to. It's tricky because the 529 account is owned by you, the parent, and it is your personal money. However, you have a named beneficiary and it counts as an asset for that named beneficiary. So that's a thing to look at and talk to your attorney or your financial advisor about. It's also tricky because in a lot of states, when you're creating ABLE accounts for children, I know here in Georgia this is true, the state, if you also open a 529, they'll match into a 529 account anything that you contribute to an ABLE account. And so that can be really tricky for folks who aren't thinking about the fact that unless we can spend that 529 money before they turn 18, it's going to count as an asset for them and they wouldn't be eligible for SSI. We got extra questions. Oh, all right. We got time for a couple more questions if there's other ones out there. Here we go. So I mentioned central line as a type of nutrition support. So if somebody's under 18 and they have a central line, they are eligible for SSI. That's enough to say that they are disabled for SSI purposes. Once you turn 18, I'm not sure that that's an automatic qualification anymore, but it is definitely a piece in your favor. Um, Eating no longer becomes one of the major life things at 18, but still bathroom needs are. So you would need to talk to an SSI attorney. I have not found a reliable way to find Social Security attorneys as far as I haven't found an association of attorneys who help with that specific eligibility. As far as Medicaid is concerned, not in most states, in about half of states, you have to be disabled to be eligible for Medicaid. So that's really what I'm talking about when I'm talking about SSI and Medicaid together is people who are disabled, meaning Social Security has said so. They're receiving SSI or Social Security disability, then they've met part of the qualification for Medicaid in their state. The other half of states, any adult 18 to 64 would qualify for Medicaid if they've met asset and income requirements. So that is Medicaid, unfortunately, despite being a federal program, has some state-specific rules around whether you have to be disabled or not to qualify in your state. So that would be the piece is does your central line make you disabled enough to be SSI eligible or Social Security disability eligible? Or does whatever has caused you to need a central line make you disabled enough? If you're under 18, the central line itself is sufficient. If you're over 18, you might, it's whatever the condition is that's causing the need for the central line has to be debilitating enough to make you disabled for Social Security rules. And we're going to talk, like I mentioned, in the summer, we can talk more about ABLE accounts and Social Security disability. How best to write up your consent to treatment and the types and what you don't want. For example, if they are changing your central line. So I think I know what this question is asking. Is how do you write out for your medical team and your care team what is the best things to do for you? And truly it is write it out and then it is give it to everyone. Give it to, if you have professional caregivers, give it to the agency and the caregivers who come in your house. If you have family caregivers, give it to every family caregiver. Definitely give it to your GI doctor and your primary care doctor. If there's a way to upload that information into my chart, upload it into my chart. I recently found out most hospital systems don't actually let you put your own information in my chart, but you can send it to the my chart tech support people through the chat function and they can upload it to my chart for you. Make sure your agents on your healthcare directive have a copy of your book of how best to care for you so that if you are hospitalized, they can be there to provide that information to the care team in the hospital. The nurses in the hospital, they know that you know the best way to care for yourself. They know that you know the best way to care for your loved one or your child. They're going to defer to you if you can tell them. So if there's a chance that you physically may not be able to share that information, have the book with your healthcare agent so that they can share that information. In the hospital, nurses are super interested in how you care for things. But they can only know if you can tell them. So the more information you can get in writing, the more information you can provide to your family and your loved ones for them to share, the better.
And I think probably just time for maybe one more question. There was a question about, for someone who's older, disabled, 64 years old, what recommendations do you have for adults? Less so parents of disabled children.
Yeah, so 64 is a really important age. Sorry, I missed your question earlier. First party special needs trust, where you put your own money in a special needs trust, you can only do until you're 65 years old. On your 65th birthday, you can no longer add your own money to a special needs trust. But if you were disabled before you were age 26, you could use an ABLE account still. And that age of 26 is actually going up to 46 next January. So we've got a year before that change will happen. So if whatever is causing you to need nutrition support happened before you were age 46, you can still use an ABLE account at any age next year. Having the power of attorney, having an advanced director for healthcare, having the conversations with your loved ones and your care team. So at 64, you definitely have a care team in place, and you definitely have the ability to share with them what your needs are. And next year, when you get Medicare, if you don't already have Medicare, Medicare will pay your doctors to have conversations with you about end of life planning and about advanced care planning. And so you can have those conversations, and your doctors get paid for 20 minutes to help you write out what those documents are. At 64 and on nutritional support, unfortunately, is too late to get any sort of long-term care insurance. But planning ahead for what does it look like to pay for your care out of your assets. Finding out if the state you're in will help you pay for things like assisted living or home care, or maybe move near family in another state that does help pay for those levels of care. Um, is those are the hard questions happening at this age.
Thank you so much, Kelly. I think such a great discussion, such great information. We appreciate you coming and sharing your expertise with us. Thank
Awesome.
you. And thank you everybody for your great participation and questions. The recording of this will be available on our website. If you're not already, make sure you're following us on social media and getting our emails. That way you're receiving updates about upcoming events, especially Feeding Tube Awareness Week. That is February 2nd through the 8th. We have lots of great events planned, so keep an eye out for more information. All right, thank you again and have a great week.